Hello everyone, this is Professor Paul Carrier at the Western Michigan University Thomas M. Cooley Law School, and I'm here today to talk a little bit about Contracts 1, the material for Class 4 in the sequence of our 13 classes. First, let me give you some highlights for Class 4. The idea in the old days, we had the mirror image rule, and what that would hold is that if there were any differences between an offer and an acceptance, any differences, then the acceptance was not an acceptance. It was in fact a rejection or counteroffer. We discussed that a little bit in Class 3. Today, the world, the legal world, the contracts area is trying not to have so many rejections. It's trying to hold together these agreements even though there are some slight or medium level differences between what the offer is and the acceptance is. Keep in mind, if the offer demands mirror image acceptance, that's the way it goes. The offeror is master of the offer and can specify how acceptance must be made, when the offer, time for accepting the offer lapses, etc., etc. But when it's not so specified, perhaps we can have a little bit more flexibility so that there could be some small differences, not major ones, and nevertheless find that the parties had an agreement and salvage that contractual relationship. Okay. Obviously, it reaches the court when it should have been salvaged, but then something else goes wrong and one party wants to get out of the contract. But perhaps we shouldn't let them out. It's not fair to the other side. Okay? So keeping in mind some additional or different terms in an acceptance are not necessarily rejections or otherwise known as counteroffers, and certainly not as readily recognized as rejections counteroffers as would be in the past. The best example of that is in the situation where you are considering the sale of goods. When the Uniform Commercial Code, or more accurately stated, when the state's adoption of the Uniform Commercial Code, Article 2, is in play. Because of the sale of goods, there are some specialized rules where differences in an acceptance should not constitute rejections or counteroffers, but should in fact create a bargain, offer, and acceptance. And then with the few things that are different, the courts find ways of dealing with how to interpret them, to keep them, to throw them out, but otherwise maintain the contractual relationship. And that with the Uniform Commercial Code, particularly, you will see there is a rule where at least one of the parties is a non-merchant. So there's a rule for non-merchants, or one merchant, one non-merchant. There is a different rule specific to the situation where both sides are both merchants. And the rule is different where you're involving two merchants to a sale of goods. If only one is a merchant or none of them are merchants, there's one rule. Where there are two merchants, there's a different rule. Okay, so that's very merchant and merchant specific. That's not all that common in the UCC. Most of the time it applies simply to sale of goods. For example, I sell you my bike, sale of goods. I'm a bike company selling you a bike. Now I'm a merchant, and now a special rule might apply because of the fact that I'm a merchant. All right. Either way, the UCC applies, or the state's adoption of the UCC applies. However, the rule may be different depending on who makes it, whether or not a merchant makes it, whether or not the offeree, the recipient of that offer, is a merchant. Okay? We will also talk a little bit about gap filling. When some term disappears or is not there, and yet we don't want the relationship to fall apart, we may have to imply a rule from some other place. Save the contract, imply the rule. For example, I don't tell you when the offer ends. The law implies it should end at a reasonable time. Okay? That would be an example of an implied term, a gap filler. And courts can do that as a matter of contractual interpretation. Now, UCC section Article 2-207 is affectionately known as, or commonly known as, the battle of the forms. And the idea behind that is you may have an offer, then you may have an acceptance, and then you may have a new second offer and a second acceptance, and they all go back and forth making small changes in each one. And so you have 5, 6, or 7 documents floating around, much of which are in agreement. And with only a few small changes or differences, And it's the idea of trying to maintain a binding agreement for those areas on which the parties agree, and to get, fill, or otherwise imply those little terms where there is no agreement or there's a void or an absence. And that's a way of maintaining the contractual relationship, even though something somewhat small is missing. If something major is missing, or if more than one major item is missing, like price and quantity, no bargain. But if everything like that is in place, and only small things like the exact minute of delivery, as an example, is missing, we shouldn't have the relationship fall apart. Okay? So let me see. The UCC 2207 actually deals only with additional terms. And I'll talk about those first. And then I'll talk about different terms and the knockout rule. Let me show by example, an example of additional terms. Let's say that the offer has 4 major items, A, B, C, and D. The acceptance has the same, A, B, C, and D. On those we have agreement, and we should have a contract based on those. But what about E? E is an additional term. Does that fall out? Does it make it a counteroffer? Probably not. It's an additional term, okay? So first I'll say that the UCC 2-207 subsection 1 tries to reject the common law mirror image rule. What it says is that if the parties don't demand the mirror image rule, then it does not apply, and we can try and take agreements that are close and treat them as binding obligations, even though there are a few differences. This case, we should have a binding agreement on A, B, C, and D, okay? E is an additional term. What subsection 2 of 2207 says is, if at least one of the parties is a non-merchant, either they're both non-merchants or one is a non-merchant, that E, if it's the acceptance or the purported acceptance, is an additional term. And additional terms are proposals, but they do not become part of the agreement unless the other side agrees. Therefore, if this side agrees to E, it's part of the bargain. If we have one merchant and one non-merchant or both non-merchants. If this party does not agree to it, then it falls away and we only have agreement on A, B, C, and D. E is not part of the deal. That is different if we have 2 merchants. If the merchant makes an offer and another merchant makes an acceptance with an additional term, it's not just a proposal. It, under certain circumstances, automatically becomes part of the bargain between merchants. If it's not a big deal and this party says nothing, then the contract has become A, B, C, D, and E. Where E, as an additional term, would not be part of the bargain is where the offer limits acceptance to the mirror image. It must look exactly like this and can't have any differences. So if there's a reservation of the mirror image rule, that's one way. If this party sees this new additional term and gives objection to it within a reasonable time, I agree to A, B, C, and D, but not E, then it does not become part of the bargain between 2 merchants. Or if E is a very big deal, if it's what we call a material term, if it changes significantly a right of the parties. Best example, probably, what if this party plans on going to court if there's a dispute? Jury trial, court trial, whatever. There's certain rights that come along with jury trials in court. What if the acceptance has an arbitration clause, goes outside of the judicial system into the arbitration system? Most states have found that arbitration clauses, instead of going to court, are very, very significant differences. And because of that, they are material terms. So if you have a material new term, this additional term, this party doesn't have to say anything. Because this is so material, it does not automatically become part of the bargain. It just falls out. Okay? So that's the concept of 2 merchants, 2207 sub 2. These additional terms become part of the agreement unless there's 3 things that happen. The other side gets objection. It's a material term that just changes the bargain. Or if the offer required that acceptance be exactly in the same form as the offer. Extremely briefly, well, in fact, and I should mention that. Let me talk about the knockout rule. What if you have an offer and then you have an acceptance? And two of the terms are completely different. A, B, C, D, A, B, C, E. And D is one term, and E is the other side's counterpart to it. And they do not agree. For example, D, we go to court if there's a dispute. E, we go to arbitration if there's a dispute. Those are in direct conflict with each other. They are different terms. There are certain ways of handling that, but I only want to talk about one called the knockout rule. As I understand it, it's the majority rule throughout this country. What happens is these two come along and D knocks out E, or E knocks out D. Both of them disappear, and we have an agreement on A, B, and C. And then, whatever that term is, let's say it's dispute resolution, we would use a default provision, which might be a court case. Another example, 10-year warranty. I'm offering to buy, you give me a 10-year warranty. Acceptance. I offer to sell, I accept your offer to buy, but zero warranty. You get nothing. Those are in direct conflict. They knock each other out. And what would happen then is we would look for a gap filler. And for example, there does exist one in the UCC, an implied warranty, for example, of merchantability. And that would be the warranty. Some default provision, not this one, but something that we can bring in by default. Okay? Very briefly, there is one more subsection to Article 2, 207, and subsection 3 to 2207, Battle of the Forms, deals with a lack of agreement, however, significant conduct. Let's say that we have an offer, we have a purported acceptance, neither of them agree, and they both fall apart and we have no deal. But the seller has already packaged and shipped the goods, and they're halfway across the Pacific Ocean, okay? And a lot of activity has been done with regard to what at least one party believed to have been a binding agreement. Now, so much has been done, the courts look under subsection 3 to find an agreement, and it will take the terms on which the parties' writings agree, and it will gap fill the rest, basically out of necessity. We have a deal, it'll lose too much money if we say there's no agreement. We need to find an agreement, so we will use the conduct of the parties, including their earlier writings, and take all of that collectively, and we will cobble together a fair agreement that honors the rights and obligations of both parties as best as possible. That is subsection 3. That was involved in one of the cases for today. We talked about the knockout rule. That's done. Case highlights. Livingstone, the first case. There's a trick in there. There was an offer. There was a rejection. No, what's your cash price? That's a rejection, a counteroffer. And the first side came back, and this is the trick. The first offeror renewed his offer and said, no cash price, you got to pay the original price, but I re-offer to you at the original price. And at this point, that party said, okay. When its counteroffer was rejected, the offeror renewed the original offer, and then the second time around, this party agreed. Now we had a binding agreement. Okay? The commerce and industry case, that is a situation where the parties tried to agree with a battle of the forms. They both appeared to be merchants, although they do not have to be for this. And they did not have enough agreement for there to be a binding agreement, so those all fell. And yet, there had been so much performance that the court needed to cobble together an agreement, and so it looked at some of the language in the writings on which the parties agreed, looked at their conduct otherwise, brought in a few gap fillers, default provisions, and cobbled together an agreement by conduct, which is subsection 3 to the article I mentioned earlier. The Klocek case, again involved, I believe, the sale of a certificate of deposit. One party was a non-merchant, and because of that, we had to use the first clause of UCC Article 2-207 sub 2, where at least one party is a non-merchant. When that's the case, an additional term does not become part of the contract unless the other party specifically agrees to it, that new or additional term. If there were two merchants, it might have automatically become part of the bargain, but since one was a non-merchant, it had to be specifically agreed to, or it fell out of the negotiations with the parties. Walker versus Keith. We had, and now we're dealing with indefiniteness. You've got nearly a contract, but one or two terms that are not quite written in stone, not quite so specific as to give serious comfort. But that, especially in the modern trend, is not a reason to throw away the rest of the agreement. And in that case, we had parties agreeing to set a price later, basically a market price later, and to decide whether we renew the lease agreement or we don't renew. And by the time we reached that point, the lessor, the owner of the property, didn't want to lease it anymore. The person who had leased it and invested in it wanted to renew the lease. So the landlord, the lessor, said, or took the position, we didn't have an agreement on that big term, no deal, we can, it just, that time period of our contract has lapsed. The other side said, wait a second, we agreed to agree, and we can use market price for similar property in a similar area. And that should be enough, and a court could now imply what that market price should be. And so there's enough here to keep the agreement together and to keep that option open, and we have a good mechanism to determine what the new option price should be. Therefore, we should continue this agreement, exercise the option, move forward, and the court agreed with the lessee, not the lessor. The contract was to continue. Final case, Rigo versus Decker. Interesting case, primarily because it deals with specific performance. There are legal damages, which are monetary money damages. That's the typical way of considering legal damages. I breach a contract, you lose $1,000, I should pay you $1,000, plus possibly consequential damages, incidental damages, some things like that. If, however, I'm trying to make you do performance, that is a different animal. So having you pay me $1,000 for losses you caused to me is one thing. Making you come to my garage and paint it when you don't want to is completely another. And making you paint would be specific performance. And that is an extreme remedy that courts don't often agree with, okay? Typically, when you're dealing with sale of goods and UCC issues, specific performance is possible, but unlikely, just as I mentioned earlier. The good news in this particular case is we actually had a land sale, and land sales are outside of Uniform Commercial Code. Remember, common law for employment contracts, services contracts, land sales, etc. This is not specifically a Uniform Commercial Code sale of goods case. However, the court in that case, by analogy, relied on the logic behind the UCC and found in this particular case there was reason to use the UCC provision on enforcement, specific performance, and the seller who wanted to breach or not sell was ordered under the same concepts as the UCC principles to actually sell the land to the first party who had accepted it. Okay, to recap, we talked about the ability to have an acceptance, although there might be some minor differences in the acceptance. We talked about UCC 2-207, where we had these additional terms, and whether it involves merchants or at least one non-merchant. We also discussed different terms and the knockout rule. And then at the very end, at least to a little degree, we talked about where there is some kind of absence, some kind of void in two parties' agreements that nevertheless shouldn't be fatal. We should still find a contractual agreement, and we find ways of implying or otherwise cobbling together the term or terms necessary to maintain the sanctity of that agreement. Thank you.